I'll let you guys introduce yourselves, and I'll hand over the mic to you, Filip. Thank you to Elina and the team for joining us and preparing and making this possible.
Great. Thank you, Sebastian. Thanks everyone at SUP as well. We are from KPMG here, and we're really happy to get this opportunity to come and discuss and to have this webinar and workshop with you all, and you guys from SUP as well, on some relevant tax issues and legal issues that we see as relevant for startups, scale-ups, and entrepreneurs in general here. Well, I'm not going to say that much about KPMG. I do think that you all know about us as a Big Four firm, so I'm not going to go into details on that. But it might be a bit sort of interesting to know that we work a lot with startups, we work with entrepreneurs, and we work a lot with sort of growth companies as well. So we don't work only with big companies that some might think, but we do work a lot with entrepreneurs, and we're a team at KPMG working who are focused and really interested to work with startups and entrepreneurs and growth companies and so on. So we're really happy to be here and to discuss these issues. And from the team today, I'm going to introduce us briefly here, and then everyone's going to get a chance to talk further on. But so I'm Filip Christensson. I work as a tax partner a lot with the enterprise companies and so on, together with Elina Sultan, also working in our tax group. And then we have Tannerheim and Marcus from our legal team. I think we're going to jump into the agenda here. And this is, as you said there, Sebastian, we have a quite fully loaded agenda here today. And I think we have three main topics. We're going to talk about some closely held company issues when it comes to the taxation and also holding companies. Then we're going to jump over to QESOs and what's happening there and things to think about and the opportunities there that we would like to discuss. And then it will be the legal team who will wrap up it all with shareholder agreements and issues on that. So as you see, it's a packed agenda, and I think each and one of these three items would be fully worthy to have a full hour session, but we've done it this way. And of course, we will also pick up on Q&As afterwards. So with that said, Elina, are you ready to dive into closely held company rules here?
I am. Thank you, Filip. And I will start by just give you a brief presentation of the closely held company rules, the so-called 312 rules. And then I will talk about when a holding company is required or helpful and some exit strategies. But at first, I would like to tell you a little bit about the ongoing committee work on the changes of the closely held company rules. The Swedish government has formed a committee to analyze what changes can be done to the closely held company rules in order to make them better and less complex for entrepreneurs. The committee will present its proposal in May 2024. And in this committee, there will also be changes made to the QESOs, and Filip is going to talk a little bit more about that later on. So the definition of a closely held company is a company held by 4 or fewer shareholders controlling more than 50% of the total shares in the company. The shares can either be qualified or non-qualified, and the qualification of shares depends on the shareholder's activity in the business. A shareholder who is contributing to the profit in the company is operative to a significant degree and therefore holds qualified shares. For closely held companies, there are specific tax rules in order to avoid employment tax being transformed into lower taxed capital income.
Yeah, sorry to jump in. Closely held companies, is that fåmansbolag?
Yes.
Thanks.
Thank you. Dividend and tax gains are taxed with 20% up to a so-called annual standard amount, and any dividend or capital gain exceeding the annual standard amount is taxed with employment tax, which means that will be taxed with approximately 50%. And the rules are complex, and I will not go into this any further, but I will like to explain the independent party rule just briefly. This picture that you can see here shows 4 shareholders who are all operative to a significant degree and therefore holds qualified shares. And the company has sold shares to an independent passive investor who holds more than 30% of the capital in the company. And shares in a closely held company can be deemed non-qualified under certain circumstances. And the passive investor can, for example, hold a position as a member of the board. If an independent party under the income year and the 5 previous income years has held more than 30% of the capital in the company, the shares may be deemed non-qualified even though the shareholders are operative to a significant degree in the company or a different company which carries out the same or similar business. Dividends and capital gain on non-qualified shares are taxed with 25%. And as the requirements for independent party rule are hard to meet, we apply this rule with caution in our advice with our clients.
Sorry, how do you know when it's unqualified or not? Is it just like, do you get like a scary phone call from tax authorities, or like how do you know?
No, you know, if you are operative in the business, or if you are working and you, as I said, you are active in the profit of the company, so that your contribution in your work will have impact on the profit in the company, then you have qualified shares.
So then it's just a question of making sure that you can prove that.
Yeah, and it's really complex. So I can say that for almost everyone who has formed a business and who's working in like a startup, they have qualified shares, unless they have someone who is a passive investor that holds more than 30% of the shares. Okay. So I will go over to holding companies and to tell you a little bit about when a holding company is required or can be helpful. And it depends on if the business carried out is profitable and the shareholders want to separate gains from the business risk, then a holding company can buy the shares from the shareholder and be the sole shareholder of the operating company. Dividends from a subsidiary are tax exempt due to a particular rule that is called the participation exemption regime. That means that all dividends from the subsidiary will go to the holding company with the tax exempt. The shareholders can form a joint holding company, or they can all hold shares in their own holding company. And which strategy to be used depends on the business and what the tax benefits will be. So, and in exit strategies, it could be wise to form a holding company prior to selling the operative company. If a business is to be sold to an external party, the shareholders can, in order to profit from the participation exemption regime that I told you before, sell the shares tax-free to form from a holding company prior to the sale. The shareholders will transfer their shares in the operating company to a wholly owned holding company for a price below market value. And this transaction will have tax consequences, but not as significant as if the shares in the holding company or the operating company, were to be sold directly by the shareholder. And after the internal transfer of shares, the holding company will sell the operating company, and the capital gain will, in most cases, not be taxed in the holding company. And the shareholder can take a dividend from the holding company and will be taxed for the dividend according to the closely held company rules. So this is a quite common way to, when the operative company is to be sold, to avoid a direct tax for the individual
any deadline for when you need to, let's say you have the company, the operating company that you're supposed to sell. Let's say you own it personally or privately.
Yeah.
Is there like a deadline in which you can transfer the shares to a holding company in order to benefit from this tax scheme, or like what's the common approach?
Yeah, we normally say that you should form the holding company before the 1st of January in order to get this annual standard amount according to the closely held company rules. And but the sale of the shares can be, it depends on the business. It depends if the operative company has salaries and that you want to use for the standard amount to be even higher. It depends on a lot of things. But if the holding company is to be formed, that should be done before the 1st of January each year.
Yeah. That's often good in order to reach a sort of better tax situation in relation to the holding company, especially if you're going to have sort of the holding company for maybe a longer period and so on. So that's good.
Got it. Thanks.
Thanks.
Should we move on maybe? And I think we're going to, as you said there before, Sebastian, regarding questions and so on, but I think we take the questions for the Q&A afterwards, and then we can discuss further. And just a very brief addition to what you said, Elina, there regarding the participation exemption scheme, that I would like to raise that in Sweden we have a quite generous participation exemption legislation compared to some other countries. So that's why we see that it's quite often interesting to have a holding company in Sweden. But there are some issues that we should bring up in relation to that, and that is that if we have a Swedish holding company to shares in a foreign company, then there are specific sort of additional considerations that need to be made as to if it would be possible then to apply that legislation. And there are some other exemptions as well, but it's a good compared to many other countries, it's a good situation having holding companies in Sweden. So that was just a sort of brief addition to that when it comes to the situation in Sweden. But to talk about things that are not as good in Sweden as holding companies, that is employment taxation and our possibilities to attract talent and so on in Swedish companies, considering the taxation of salary in Sweden, and also when it comes to social security contributions for employers, of course. But there is one really good way to find a solution or to find a possibility in this, and that is in relation to the QESO rules and the qualified employee stock options, what we call in Swedish kvalificerade personaloptioner. And so what we're going to talk about today is some what's going on the rules, and some questions that we see often, and we want to talk about the future as well, maybe in relation to this legislation and the items that leads to discussions on. But before we do so, maybe we should just talk briefly about the tax consequences when we talk about qualified employee stock options. I think I said the Swedish term before, kvalificerade personaloptioner, right? Yeah. So and I just want to add to is that it is really important that we talk about that this is in relation to what we call personaloptioner in Swedish. So either they can be qualified or non-qualified. Then we can also have sort of other warrant schemes and so on, but they could be sort of, they could qualify as securities and so on, and that's a completely different chapter. So now we talk about employee stock options, what that is the Swedish term personaloptioner, and then we have qualified and non-qualified. And if we talk about then, so what's happened during the time, and we have the situation here with the increase in value over time, and that the acquisition, when you get these qualified employee stock options, well, nothing happens on the taxation. And then when we utilize the options to acquire shares, then at that case, if we have a qualified employee stock option, then there will be no taxation at that time. If we have a non-qualified employee, like a normal employee stock option, then we would have a taxation of the increase in value from the acquisition up until this time. And then the problem with that is that then we often end up in a situation where we will have to pay employment tax, but where the only thing that we have done is that we have acquired shares. We have used the options to acquire shares, and then we get a taxation. And then in most situations, maybe we don't have any possibility to actually divest the shares, and then we have to pay tax without having received any cash. So that is the reason to why we have these qualified employee stock options. It was this major problem that we have a situation where people actually got what we call dry tax, i.e. that you had to pay tax without having any cash to pay the tax. But when we have the situation where we have qualified employee stock options, then nothing tax-wise will happen at the time for the utilization. So that's the good thing about these qualified employee stock options. But then we should remember that afterwards, when we have the shares, if we then sell the shares or if we receive a dividend, then we, in most cases, will come back to the situation that Elina described, i.e. that we will have the situation where they can be subject to employment taxation under what we call 312 rules, or the closely held company rules. And so that is the reason. So in the end, we can still end up with a employment income taxation of the increase in value from the acquisition up until that we dispose of the shares. And if we talk about this sort of, can we change the slide there? So if we talk about what has happened here, it's that we have had some change rules from the beginning of 2022, i.e. that is in relation then to options acquired from the beginning of 2022. There are new rules compared to the situation before that, and these new rules are, well, slightly better when it comes to these different requirements that we're going to talk about. We also have some recent case law that I would like to bring up, and that is in relation to there's a 10-year requirement that says that the company that these options refer to, if we are to meet the requirements for the qualified employee stock options, the age of the business may not be more than 10 years, or 10 years. We're not going to go into details on the measurement there, but we have this 10-year requirement that's the oldest possible age of the business. And then there are also special rules regarding if there have been transfers of business between companies and so on. And now we have had two recent case law here, one from the Supreme Administrative Court, Högsta förvaltningsdomstolen, and one from the Board for Advanced Tax Rulings, which is Skatterättsnämnden. And both of them have been in relation to such situations, and both of them, the outcome have been restrictive in both these cases. So it's really important to consider these recent cases when it comes to situations where we have had sort of transfers of business in between companies. And if we talk about other good news coming up in relation to the QESO rules, is that's what also Elina mentioned here before. This 312 committee, or the closely held company committee that is working now, there will likely be some, or hopefully there will be some changes in relation, or at least some suggested changes on how these sort of the 312 rules can be better off, or can be changed in a better way to make it easier, maybe to not having a employment taxation situation if you sell shares that you have acquired through QESOs, but where you still have a closely held company situation. And common challenges here, I would say that it used to be sort of more questions on actually how we should what should be done in order to sort of to have the formalities right, and how an issue of qualified employee stock options actually should work. There used to be more such of sort of questions about formalities and so on, but now we see that the questions we get on this is actually how to be what actually that we provide information on the requirements that need to be fulfilled, and that we make sort of assessments if the requirements are fulfilled on a case-by-case basis. Because the requirements are really, really detailed. And if not, it doesn't matter if it's only a minor detail that makes you differ from the requirements, then you end up in a situation where you can make use of the rules. And of course, that's negative. So I would say that currently it's regarding these very detailed requirements that we have most issues. I've only listed some of the requirements here, but we can of course provide more info on that. And then of course also this in the end that we still have an employment taxation in many cases. That's of course a sort of problem, and maybe not what everyone would like. That we would like instead to be able to have a sort of capital tax situation in the end. But hopefully there can be some part of that coming from the committee going on here in relation to the improvements of the QESO legislation. There.
All right, thank you guys. Hi everyone, my name is Tannerheim and I work as a senior manager with KPMG Legal Services, mainly working with corporate commercial, M&A and data privacy questions. I have previous experience from working as a legal counsel with a large cap company, and also working at a law firm prior to joining KPMG about 4 years ago. I also have Marcus with me today, my colleague. Want to introduce yourself?
Of course. Hi, everybody. My name is Marcus From, and I am a senior associate working together with Carl at KPMG's Legal Service Department, with a primary focus on M&A and corporate legal matters. I joined KPMG about 6 months ago, but besides my time here at KPMG, I also have about 2.5 years of experience from working in a very similar role at the Legal Service Department of another Big Four accounting firm.
Great. So for you who don't know what what KPMG Legal Services is, we are in many ways like a law firm. We assist our clients with different commercial matters such as corporate, company law, M&A, employment law, data privacy, you name it. And one of the exercises which is quite common for us is assisting clients with shareholders agreement, and hopefully we can somewhat provide a high level knowledge to you guys today and explain why it's important to have it in place and help you setting up what you might need. So having the agenda in front of us, it's a brief agenda, but it's also a very short amount of time that we have at hand. So, but initially I will just have a short intro about what a shareholders agreement is and why it is important. Marcus will continue to speak about the differences between the shareholders agreement and the articles of association. I will follow it up with some examples of what a shareholders agreement usually governs, and then we'll just touch base on the use of templates and why we believe you should use caution when applying them. So jumping straight in, the next page. So what is a shareholders agreement? Well, it's an agreement between the shareholders, and I believe that there is no surprise to anyone. The reason for me stating it so clearly is that it's very important to keep this in mind when working with shareholders agreement. The purpose of the shareholders agreement is to regulate the ownership of the shares and the execution of the company's business, and it's also somewhat of a code of conduct between the shareholders during the term of the agreement. So what it does regulate is what we're going to do with the company, what are we not going to do with the company, for how long should we continue doing it. For example, when should we just step away and leave it as it is? So when should we exit? What other stuff are we obligated to do around it? And also, what could we not do? What are prohibited? So what the agreement does not regulate is how third parties shall act. So it's not like the terms and conditions on how you're supposed to make business with the company from the perspective of a third party, nor making business with the shareholders. In addition to this, the company is not a party to the shareholders agreement, and this means that third parties nor the company are bound by any restrictions written in the shareholders agreement. And the company may still, irrespective of what the shareholders agreement states, enter into specific agreements and settle specific disputes, for example. So having this in mind, you will have very little success in pointing towards the shareholders agreement when trying to get out of an agreement entered into in contradiction with the shareholders agreement, or trying to buy back shares from a party who has sold the shares in contradiction with the shareholders agreement. So conclusively, just for this short intro, it's a contractual obligation, and you should keep that in mind, which is only binding towards you as the shareholders who have signed the agreement. And the only remedies that you can actually use as main rule are buyout of shares, damages, and in some cases penalties. Marcus will now highlight the differences between the shareholders agreement and the articles of association. Will bring some more clarity to this.
Thank you, Carl. So what is then the relationship between the shareholders agreement and the articles of association? And just to get that out of the way straight away for you Swedes out there, the articles of association is, of course, the bolagsordning in Swedish. And to get an idea on how these two instruments compare, we should also touch briefly on the nature of the articles of association of a company. The articles of association are a set of rules adapted by the general meeting of the company and can in some sense be considered as a constitution of the company. The rules laid down in the articles are in principle binding towards more or less everyone, including the current and any future shareholders in the company, as well as the company itself and the different bodies of the company, such as the general meeting and the board of directors. And looking at only these two aspects of the articles of association, that they're binding towards everybody and that acts in breach of them are simply invalid, they may for good reason seem like a great instrument to use in regulating the cooperation surrounding the company. So why then do we not use only the articles of association when regulating our cooperation as shareholders? There are two primary reasons for this. Firstly, and most importantly, there are significant limitations on both the type and the content of provisions that can be included in the articles of association. So if one wants to go beyond what these limitations allow, the only option to do so is essentially through a shareholders agreement. And secondly, it's good to note that the articles needs to be filed with the company's registration office once adopted, and they will consequently be available to the public. And as you know, shareholders may, for commercial or other reasons, want to keep certain parts of the arrangements surrounding the company private. And in such cases, it's a shareholders agreement that is the viable option. So to summarize, the key differences between the articles of association and a shareholders agreement are that the articles of association are in principle binding towards everyone, while the shareholders agreement is only binding between the parties to the agreement, as Carl stated. The consequences of an act in violation of the articles of association is in general invalidity, while the consequences of an act in breach of a shareholders agreement is generally that the breaching party will be liable to pay damages. And there are significant limitations on what can be included in the articles of association. While there are
sorry, Marcus.
Sure.
Just from what do you mean with breach of general result in invalidity? What does that mean?
Yeah, sorry, I thought I addressed that earlier, but yeah, invalidity in the sense since we're talking about many different kinds of acts and resolutions and agreements, it's a bit of a simplification, but invalidity in the sense that if, for example, the managing director of the company enters into an agreement which he or she does not have the authority to enter into according to the articles of association, that could normally, or depending on the circumstances, you could argue for that agreement being invalid. And also if, for example, the board of directors make a resolution which is in contradiction to what is decided in the articles of association, then that resolution could be declared invalid. So the terminology, of course, differs depending on what sort of, or what we're talking about. But in general, you can make the thing that breached the articles of association simply disappear, rather than having to go down the lane of claiming damages from a breaching party.
Got it. Okay, thanks.
No problem. Yeah, so difference in the consequences of breaches there, and then also the limitations, pretty extensive limitations, what can be included in the Articles of Association, while there are very few limitations on what can be included in the Shareholders Agreement. And finally, the question of public versus confidential as well. And having explained these key differences, we hope that you might start to get an idea on how these two instruments can be used to complement each other. On a very high level, you want to use the Articles of Association to establish certain fundamental rules, which will be binding towards everyone with very strong safeguards tied to them. And then in the shareholders agreement, you can include a more elaborate and tailored solution, which you have agreed upon with your co-founders and investors. And one final note on the topic of the differences in terms of which parties are bound by and what the legal effects are of these instruments is that contradictions can actually occur between what is stated in the Articles of Association and in the shareholders agreement. And such contradictions are actually in some cases even desirable. We're not going to delve too deep into this topic since it's slightly theoretical, but it is, for example, often a quite good idea to include in the articles a sweeping restriction on transfers of shares in the company, which will then effectively prevent any third party from acquiring shares in the company without your consent. But then it may also be a good idea to include in the shareholders agreement a provision which first simply states that the transfer restrictions in the Articles of Association should not be applied or invoked between the parties to the agreement. And then the provision lays out a more elaborate procedure for how a shareholder actually should go about in case it wants to sell its share in the company. And that was what we were planning to say about the relationship between the two. And moving on then to the topic of what a shareholder agreement should cover. One thing to remember in this regard is that there's no shareholder agreement law or other definitive standard which dictates what the agreement should or must cover. Instead, you're allowed to regulate more or less anything in the agreement as long as it is not prohibited by law or otherwise considered unreasonable, wherein unreasonable provision could, for example, be one that creates very strong long-term lock-in effects or one which prescribes very high penalties, which could be deemed unreasonable. But despite the very broad opportunities here, there are, of course, some types of provisions which are more common than others. And our idea was that Carl would now briefly take you through at least a couple of these.
Yes, perfect. Thank you, Marcus. Yeah, so we've divided these examples into two categories just to try to highlight that there are differences within, like, what's the purpose of some clauses and there are other purposes with other clauses in terms of what do you want to regulate other than what is specifically written. So in this left column, we have something regulating more the company's business and the operations of the business, while on the right side, you have how the shares are owned, like how the shareholders are supposed to act when they own the shares. So if you start on the upper left side, with the purpose of the company's business is a clause which I try to emphasize quite a lot towards my client. And the reason for this is that it's important to align every shareholder that they like pulling in the same direction. Everyone always have some sort of alignment when it comes to on a high level, but once you're going to put the pen on the paper, everyone starts having opinions which maybe haven't been brought to light earlier. So this is quite important for me, especially in the discussion phase of the agreement. Next up, you want to have or usually at least, a provision stating how the board of directors should be composed. And that goes both for how many directors should we have, but also how many directors should each shareholder be allowed to appoint. And there are various solutions to this, but for example, a majority shareholder who has 51% of the shares in the company would likely want to have majority in the boardroom as well. Why then you need a provision stating that he or she are entitled to appoint one more shareholder than the others. Moving on, additional financing and distribution of profits. So you want to have a provision which states that the shareholders are obligated or not obligated to provide additional financing for when the times are tough. If you don't have a provision stating that you must provide additional funds if necessary or required, then you can't force the other shareholders to actually put in more funds, and then all of a sudden all your efforts, just historical efforts, may be gone to waste all of a sudden. And on the other hand, if the company actually goes well and you get additional funds, do you really want to make any dividends straight away? Do you want to wait for maybe 3 years, or do you want to reach a specific liquidity or solvency, for example? And that should be inserted in the shareholders agreement as well. On the right side, that means how are we supposed to own the shares, or how are we managing the shareholder structure. You have to have provisions stating how we're supposed to introduce new shareholders into the agreement. Is it sufficient with simple majority, 51% votes, or should everyone agree to it? Should we have 80%, or what's the how should the decisions be made, and also how should the procedure look like? And on the other way here, how should we get rid of someone who is toxic to the environment? How maybe breaches the agreement every now and then, does whatever he or she like? Then you need to have a procedure for that as well. And on the same theme, you have something called good leaver and bad leaver clauses. And the purpose of this is to give an incentive to follow the agreement even more. Where a good leaver is someone who divests his or her shares by way of redemption, so the other shareholder buy his or her shares due to specific circumstances such as pension, sickness, maybe changes job, then he or she will be considered usually a good leaver, meaning that he or she will also get full compensation for his shares. While a bad leaver is someone who has breached the agreement, for example, non-compete, and then he or she will probably get somewhere around 50 to 80% from the market value of the shares. And I believe Elina and Filip will touch a bit on that afterwards here. And finally, as an example, you have the non-compete clauses, and these are very important to always have in mind, because a lot of times, especially in startup situations, the shareholders sit with a lot of company-specific knowledge that if taken somewhere else, it might do real harm to the company. So you want to ensure that no one can just quit and straight away start competing with them, either by starting their own business or otherwise going to a competitor. So these are just some examples, but as Marcus previously said, there is no law, so there are endless opportunities as long as it's not prohibited by law, like surrounding laws or otherwise unreasonable. So the sky is the limit somewhere. So for our last slide, we just briefly want to talk about the use of templates. We see our clients coming to us quite often with template-based agreements and wanting us to sanity check them prior to signing them. And more often than not, we have a lot of comments on them because they are often not adapted to the client's real business. We also work a lot with templates, but it should only be used as something that you start with and then develop until it's all adapted to what you actually need. You should always bear in mind that for some of you, and hopefully all of you, the shareholders agreement will be the most important agreement that you will ever sign, because maybe in a couple of years you will be the next tree who have risen to the stars and be valued at so much money. But between now and then, a lot of things might happen, and it's important to now, when you're all aligned, you're all good partners, come together and put pen on paper on what you actually want with the company and how you should proceed in the future, depending on what happens. So use templates, but use them with a lot of caution. And this brings us to what can KPMG offer you here. So we all see you, of course, as potential future long-term clients, where we want to try to be able to provide you with easy, accessible, and effective legal assistance as you need and when you need it. But we of course understand that it might not be prioritized to put legal costs at this state, because there might be other costs that are more valuable for the business short term. But therefore, we have constructed a slimmed down process where we provide you with a template, or rather a questionnaire, which you complete. We then review the questionnaire and provide you with an adapted template, which is more suitable for the business. Not full-blown suitable, but goes a long way further than just downloading an online template from a free website or whatsoever. So in addition to this, we'll also list matters which we believe are important to you, both in connection with the Shareholders Agreements template, but also otherwise other topics which we believe are relevant for you. And then you can decide whether you want to engage us or not, or whether you want to go somewhere else, of course. So that's pretty much what we wanted to say, and it was right on time for once. So wish you all good luck with all your companies and ideas and businesses.
Awesome. Thank you, Carl. We're right on time for the Q&A. I've certainly made some notes. I can't help diving in sometimes. So apologies for challenging you guys on keeping everything on time, but you managed to do it. Before we dive into the Q&A, as promised, I'm just gonna push a poll. So please respond to this one. It's anonymous, and it will help us understand what we should focus on and if this is helpful or not. So while you guys answer, anyone want to jump in with the first question? Niklas, what a gentleman, raising your hand. Go for it.
Thank you. So a specific question on lock-in, lock-up, and vesting. So you were talking about unreasonable terms. What would you consider standard terms when you take on board external investors as for vesting?
I would say that depends on circumstances, as all legal answers do. But everything beyond 2 years, you need to consider other options, not other options, but you need to consider whether it is reasonable or not, and then make an adjustment depending on what the outcome is. So there is no hard line, unless you know it, Marcus, that you've read something.
No, but I was just wondering, when you talk about vesting, Nicholas, do you have a particular setup or strategy in mind? Because I think the 2-year time frame mostly relates to, or correct me if I'm interpreting you wrong, Carl, but non-competition clauses, perhaps.
Yeah, I think looking into the startup docs, and we have an early version of that. We've been a long time SUP 46er, so we've used everything. And I think we have a 4-year vesting in that standard, which is may or may not be reasonable for a very early stage company where the founders and team is everything, and then you come with a PowerPoint. But once you're generating revenue and you're a bit down the road, in my mind, that's not really reasonable. But then again, looking at Almi standard, for instance, and a few others, there are still 4-year vesting periods. So that's hence my question.
Yeah, what you need to have in mind is that it all springs from the main rule that a share must be able to transfer to a third party. It cannot be locked in forever. So from that main rule, you need to look at what is vesting, and it is impractical that you're not getting paid full value for your shares. So until the vesting period has ended. So in all that, you need to look at the actual effect of the vesting and see if it comes to the actual effect of the the share actually being untransferable or not. So that's a specific question we can give right now, but it depends on the circumstances at hand, and yeah, it's hard to give a straightforward.
Yeah, and to keep on with the Swedish translations, the standard that you judge these questions against is whether it's not oskäligt in svenska, according to the avtalslagen, which is a very unspecific rule. So
it's very broad, very
depends from case to case.
Yeah, very case dependent.
Right.
Yeah,
Maybe say
maybe.
that as you said there, sorry, Sebastian, I'm just gonna just add to that also, as you mentioned, I don't know if it was Marcus or Carl before, but there is also the tax sort of perspective when it comes to restrictions in shareholders agreements, that we do have a sort of case law system also on what sort of restrictions that can be in place for tax from a tax perspective without leading to negative tax consequences, especially for employees who acquire shares in the company and become subject to a shareholders agreement. So it's also important from a tax perspective to take a good look at the restrictions when it comes to vesting periods and also transferability of shares and bad leaver situations and valuations in bad leaver situations.
Thank you.
On the topic of vesting, I think Niklas touched a little bit upon it. Sometimes when a new investor comes in, they're telling the entrepreneurial team, the existing co-founders in the team that might already been vesting for 3 years, to say like, no, you need to reset your vesting because we want you committed. Like what's skäligt or not in this case? Like, what's your perspective on it?
I don't know if I touched on that any time, so I wouldn't dare to answer. I could get back to you guys on an email response if you'd like that, but
I think one perspective on that question as well is, as stated previously, it depends from case to case, but it's important to keep in mind that like judging whether or not it's oskäligt, unreasonable or not, in the end, to a large degree, boils down to what you get in return for accepting such an extended vesting period. And the same thing with the initial vesting period. So I guess you would have to look what you get in return as well to be able to say something about that.
Yep, thanks. Anyone else want to jump in? Okay, while you guys digest, I have a couple of things written down that I know are relevant to many. The set vesting scheme for QESOs, that there's a minimum amount of vesting time. Is it 4 years or 3 years?
It's 3 years.
3 years.
Yeah.
And for many, that it's considered being quite a long time. And it's not just vesting, it's for the cliff, right? So as far as I understand, an employee needs to be with the company for 3 years before they can even keep any of the options or execute any of the options that they're offered. Could you just elaborate a little bit on what that means and why is it 3 years and not 1 year, as it's more popular in like Silicon Valley environments? Like I'm talking about the cliff now.
Yeah,
specifically.
Yeah, so it's regarding as I was on one of the slides there, it's you can only the options need to be used after 3 years and before 10 years. So that's a time span that when they need. And I think it all comes down to sort of a Swedish perspective on that you need to be involved for a long time and need to show that you have any sort of engagement and an incentive or should sort of a motive to work for the company for a long time. So I think that's I don't think there is any sort of specific thinking about the 3 year period either other than that, I would say.
But it basically means that an employee needs to work at least 3 years at your company in order to benefit from the options. Did I interpret that right?
Yeah, you need to have that for 3 years.
Are they like looking into this? Because for many, it's like some companies or some employees leave before that, and one could say like they should be more committed long term. But the reality in startup land is that many employees are not staying at one company that long.
I can look into that. I don't have any sort of, I can't say offhand exactly on how it's seen, but I can check around to see what the status is on that.
I can actually say that that's one of the main reasons that the government made these qualified stock options, because we have other stock options and they are not that well, how shall I put it? They are quite good for the employee if all the requirements are met, and I think that was one of the reasons why we have the qualified stock options, because that you were supposed to be working for the company for 3 years, and that was one of the main reasons.
Got it. Thanks for elaborating, Elina. It's still a little bit unclear, like from a operating point of view. Like it raises a lot of questions, at least from what I've heard. But you haven't heard any like rumors or reputations that this will be discussed or revisioned, or?
No, I haven't heard anything. We'll see what the committee will come up with, but I don't think that there will be any changes to the 3-year requirements.
Got it. Okay, thanks. One thing regarding your templates that you talked about briefly.
Yeah.
Could you mentioned that it's fixed. Like, could you give us a number what it costs?
Yeah. So 15,000 Swedish crowns, and that includes also a brief meeting just to explain what the product is and give you some suggestions on how you may adapt it to better suit your business. The agreement itself will be quite usable, but there might be minor adjustments that might be necessary just to ensure that it follows your ownership structure and your potential vesting interest and stuff like that.
Got it.
It's at no profit margin for us, so it's just to bring you up to what you need to be.
Niklas, go ahead.
Can you repeat the number, Carl?
15,000. 15,000.
Yeah, I heard 50, so 15 is different. Thank you.
Yeah.
15,000 euros.
Yeah, exactly.
I have another question if there is no one else.
Yeah, go for it.
So you mentioned right at the beginning that about qualified and non-qualified shares. So, and you said that there might be uncertainties even if you have external passive investors on and beyond 30%, that you might still be qualified. Can you elaborate on that?
Well, I would love to. I think that this could take a lot longer than 3 minutes, but it means that you have to look really carefully into every person who is a shareholder's activity in the business. And you have to look at the investor, if he or she has any activity in the company that could, for 1 year, because you have to look at this year and the previous 5 years. So for all that time, the investor cannot have had anything to do with the company as of any activity to this degree.
Right. And you say investor. So is it required that one investor holds 30% plus, or is it a group of investors?
It can be a group of investors.
Right.
This, as the Swedish term utomstående has been subject to so much case law the last few years on the situations, and there is also one sort of, I would say, general sort of rule on that doesn't apply if there are specific circumstances and so on, because it's a tricky rule to apply, and that's why there are sort of new questions coming up all the time on how to apply it, and especially regarding these. In the last cases, it's been concerning this sort of specific circumstances and if they can apply against an application to the rule. So that is apart from just the sort of calculating and applying the rules just on a sort of step-by-step level. You need to have that overview, or sort of total overview as well.
Got it. Thanks.
So that is,
yeah.
So I think that's been like, I should say that's been, whenever we talked about these rules for the last couple of years, it's always been like, if you have a situation where you sort of would like to apply the utomstående regeln, then it's really important that you make sure that all requirements are fulfilled and that you're also very up to date to what's going on in case law.
Good, perfect. Thanks for that, Filip. And we have the contact list for all the KPMG team if you guys want to reach out. Also, hopefully, we'll add a little SUP 46 member exclusive mega ultra perk on startuppeople.com, which you can find contact details and so on. So with that said, thank you the KPMG team, and especially Filip and Elina for coordinating, and to Paul, who are running the slides in the background. Shout out to him. And also SUP members and the community for joining today. And stay tuned for upcoming sessions. We're going to do employment law in a couple of weeks, I think. Calendar invites coming soon. So thank you guys for joining, and have a great afternoon, everyone. Take care.
Thank you so much, everyone.
Thank you very much, Sebastian.
Thank you.
Thanks.
Thank you all. Bye.
Bye.
Bye.